The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, be seated, please. All right, first case we'll hear this morning is South Carolina State Conference of the NAACP versus Weaver. And Mr. McLaurin, we'll hear from you.
Good morning, Your Honors. May it please the court. Charles McLaurin for the plaintiffs. This is a case about state politicians and state lawmakers injecting their preferred viewpoints into K-12 classrooms and prohibiting opposing viewpoints that they disagree with.
So, counsel, for today's purposes, we're just dealing with standing.
That's absolutely right,
just
Your Honor.
standing.
This is a narrow appeal on the dismissal of a 12B1. The defendants are wielding the budget proviso to censor coursework, instruction, and books that address disfavored aspects of race and racism. And by doing that, they're depriving students access to facts, information, and ideas essential to their understanding of their own history. The district court's dismissal order on standing grounds should be reversed for two independent reasons. First, the district court was factually incorrect when it characterized the defendant's alternative justifications as unchallenged. That couldn't be any farther from the truth, as the plaintiffs have challenged the defendant's alternative justifications as pretextual and not credible. Second, the district court improperly folded merits considerations about the defendant's motives into the court's standing inquiry and resolved factual disputes in the defendant's favor. So I'd like to start today with a discussion of the plaintiff's First Amendment claims and then proceed to the 14th Amendment claims, but I'd be happy to take things in a different order if the court so wishes.
Let me ask you about a couple of the specific plaintiffs. First, J.S. And as I recall, her claim to standing is based on her mother attempting to enroll her in the course. Has she graduated?
She is not, Your Honor. She's still enrolled in a public high school in South Carolina. She's actually a current senior.
So when will she graduate?
She is expected to graduate in a few weeks, at which point there is a possibility that her claims may be mooted out. But I would like to point the court to student plaintiff A.G., who's a current sophomore, and A.G. actually enrolled in the course, and the district court was correct when it recognized this, that
Right.
A.G. enrolled in the course. He was then ejected from the course as a direct result of defendant Weaver's removal of the course
All
code.
right,
And that alone.
Okay, but A.G. is not an individual plaintiff.
Well, AG is a student member of an individual plaintiff, the South Carolina NAACP.
Right.
And through AG, so that alone satisfies the injury
Let
problem.
me direct my questions. So can you, as far as J.S. is concerned, can you make a representation to the court in a 28J letter as to her date of graduation?
Yes, we can do that. I think
Okay, so let's move on to AG.
Well, just on that, wouldn't it be, all right, she can't take another course at this point, can she? She's cleaning up, she's finishing. Whether we have the actual date, the date would be nice, but her circumstances are done, right?
that might be the case, Your Honor.
She can't enroll in a course now.
Well, I think that is sort of an unfortunate consequence of the fact
I'm talking about factually now.
that might be factually correct, Your Honor, just given that, we filed this lawsuit, I think, about a year and a half ago, a few months after the defendant removed the course code. And at that point, she could have been able to sort of take the course had the district court granted the plaintiff's injunctive request. But that request was denied. So at this point, like Your Honor mentioned earlier, she is scheduled to graduate in a couple of weeks. But with student AG, Student AG's
All right,
facts.
let me go back to reframe the question as to the NAACP, because that's representational standing. So if we just assume that the individual plaintiffs either don't meet the Lujan test, or if, as to JS, it's mooted, then the remaining plaintiff for standing purposes is the NAACP, which would be a representational plaintiff. So in that case, it would have to have a member, AG, who we'll assume has standing. She was enrolled in the course, and then the course was canceled. The district court, however, didn't make a finding. It only assumed that she had standing. And I don't see in the pleading or in the district court's decision that it ever made findings as to the elements, the other elements of representational standing. Is it germane to the organization's purposes? And does it require AG's individual participation? That may be correct, but I don't think on this record at this time any of those findings were made. Is that correct?
I think that's right, Your Honor, because the organization is pursuing an associational standing claim. This is not an organizational standing, so the standing is buttressed by the facts of its individual members, student members, AG. And if I can just sort of make one correction to Your Honor's point earlier, there is another student, TR, who independently also satisfies the injury in fact prong of Article 3 standing.
I premise my question just on if we assume the others do not meet the requirements. Not that there's a finding, but if we were to conclude that the only plaintiff left standing is the NAACP, then at this point, we don't have findings on the record that establishes its representational standing. So in order to do that, wouldn't have to go back to the district court to make those findings in the first place?
Well, that is correct, that we don't have findings on the record yet. The dismissal, I mean, to be candid, the order itself is not exactly a model of clarity. It just, you know, it's...
No argument there.
Yeah, it you know, in one fell swoop dismisses the plaintiff's 96-page complaint without even a mention to the plaintiff's 14th Amendment claims, for example. And, you know, had the district court properly analyzed the equal protection claims, for example, it would have been forced to allow that claim to proceed to discovery. I think.
Last question for a while, but because your statement reminded me. If we were to determine that there was no standing as to counts 1 and 2, am I correct, the district court did not make a specific finding as to counts 3 and 4? And so it would have to go back to the district court to make those findings on those claims in the first instance.
Well, I think with respect to standing, I think this court is empowered to make a finding on those claims, specifically
right, but we
with
usually don't. If the district court didn't pass on it, and it doesn't look like to me that they did, if you think they did, please tell us. But if they didn't, normally what we would do is just send it back to the district court and say, you didn't make this determination earlier, make it now.
Yeah, well, a couple of points. I don't think that would be the optimal solution here. I just think that in the interest of judicial economy and efficiency.
Except the Supreme Court's made pretty clear, while our role is distinct from the district court's role, and the district court, we rely on to make findings, even if they're just findings with respect to different affidavits and conflicting affidavits. We could do the same thing, but I think it's pointed out pretty clearly that that's not our role to.
Yeah.
And maybe in an exceptional circumstance, I'm not sure what the rule is on the exceptional circumstance, but
Yeah.
generally that's not our role to find facts and to sort them out and to comb the record and determine what supports it or not.
Yeah, well, I think this sort of harkens back to my conversation just a minute ago about the lack of clarity of the district court's order. It's not clear if the redressability analysis is exclusive to the First Amendment claim or if it applies to the other claims, right? And at which point the redressability analysis applies to all of the claims, then, like, for example, that would sort of give this court the jurisdiction to sort of weigh in and to assess whether or not the plaintiffs have sufficient Article III standing for the 14th Amendment
What happens
claims.
if we can't tell?
Well, I think that I think that again, I think even if this court was not sure, I think the optimal sort of solution would be to sort of rule on the 12b1 dismissal, which, because if the court does not, or if the court, if the court did not, that would sort of leave open the possibility of like endless appeals, and we think a ruling here would obviate the necessity of additional appeals, which can take years on the 12b1. So I think, again, at which point the court does think that the redressability analysis was not limited to the First Amendment claim and applies to the 14th Amendment claims, I do think that this court has jurisdiction to rule on the 12b1. And these aren't findings of facts. These are essentially legal questions as to whether or not the plaintiffs have suffered a concrete particularized injury that a favorable court order could remedy. I do think that this court does have jurisdiction, and I do think that we're properly before this court on all of the claims. And if I can just quickly go back to the student's injury, the fact that AG was enrolled in the course and then subsequently enrolled in the course, that alone satisfies the injury prong, and there's no need for this court to even consider whether or not the other students were injured for the same claim. It's a pretty straightforward injury for First Amendment
But
claims.
she's not an individual plaintiff. You've got at least two individual plaintiffs, but she's only, you tell me if I'm wrong about this, she's only here as a member of the NAACP. She's not making a claim in her own right.
Well, that's correct, and so the South Carolina NAACP, though, that they are a plaintiff, and the fact that one of the plaintiffs has a pretty straightforward injury under Article 3, that alone satisfies Article 3 injury for this claim. So there's no need to for the court to assess whether or not the other plaintiffs have an Article 3 injury for the same claim, and this court has been pretty clear on that sort of is the standard. So just for example, in Rumsfeld Forum for Academics and Institutional Rights, the court made pretty clear that the presence of one party with standing is sufficient to satisfy Article 3, and there's no need for the court to consider whether the other students or the other plaintiffs are standing for that same claim.
So based on the declarations, AG is currently a sophomore or junior in high school?
Correct. AG is
So
currently a
she's got some
sophomore.
time.
Correct. And then Dr. Kennedy's injuries are also pretty straightforward because he alleges that the school district defendant removed his book stamped from the library because of the budget proviso's prohibition against the viewpoints within the book stamped. So under this court's precedent, this type of censorship, namely viewpoint discrimination, is sufficient to satisfy the injury in fact prong. If I can turn to the redressability prong, the state concluded that the AP course violates the budget proviso, and Defendant Weaver's enforcement of the budget proviso now stands as the primary barrier to the students being able to achieve their desired result. It's worth underscoring that the social studies state standards is still pending, and Defendant Weaver is assuming the outcome of that process. There is nothing in the record that even remotely suggests that the soon-to-be revised standards will be found to be inconsistent with the course. And as described in the complaint, the state didn't even evaluate.
That would be a merits consideration, wouldn't it? In other words, you wouldn't get to that on standing.
I totally agree, Your Honor, but the problem is that the district court did get to it, and the district court essentially made a determination that these standards actually stands in the way and serves as a barrier. So essentially, the district court erred when it, presumed that these disputed.
So you're not to make the argument for you, but I assume you would say in this regard, that's a 12b6 argument. the district court didn't make a 12B6 decision.
Well, what the district court did was the district court folded or collapsed these merits considerations into its standing inquiry, and that is an obvious no-no because it literally turns the redressability doctrine on its head, and it unnecessarily and improperly incorporates these merits considerations into a threshold standing inquiry. The plaintiffs actually provided examples of how the course is actually harmonious with the current standards. So there's no reason to think that the outcome of this process will result in a conclusion that the course is not compatible with the standards. And on the redressability, I think the main point here is that a declaratory judgment would in fact make it more likely that the plaintiffs will be provided redress. In other words, it will be more likely that the course code would be reinstated and that they'll have an opportunity to take the course. And that's certainly a sufficient tangible benefit that's enough for standing. As we described in our briefs, this court has repeatedly recognized that redressability doesn't turn on whether a favorable decision would eliminate every single conceivable obstacle that's out there. Article 3 only requires that the plaintiffs put forth plausible allegations that they would benefit in a tangible way from a favorable court order. And declaring the proviso unconstitutional would remedy the plaintiff's injury because at that point, the defendant, Weaver, would no longer be able to point to the budget proviso as a justification for removing the course and would no longer be able to point to the budget proviso as an obstacle that sort of stands in the way. Dr. Kendi's redressability analysis is pretty similar because, again, the mere possibility that a favorable court order would not return stamps to circulation, that doesn't defeat standing because he doesn't have to show that a favorable court order would guarantee that outcome. Again, similar to the student plaintiff's argument, the proviso, if the proviso was declared unconstitutional, the school district defendant would no longer be able to point to the proviso as a justification for keeping the books, or keeping his book off the shelf, and the proviso would no longer operate as an unconstitutional barrier to his ability to disseminate his speech freely without impermissible viewpoint discrimination. So in dismissing Dr. Kendi's claim, the district court relied heavily on the school district's assertions that the book is replete with factual inaccuracies, and it pulled the book because of these purported factual inaccuracies, according to documentation in the record. But that conclusion, again, improperly relied on disputed facts. The defendant's factual assertions that other considerations may have informed the committee is totally irrelevant to resolving a motion to dismiss because factual disputes about the defendant's motives lie at the very heart of the merits case here. Why the defendant did what they did.
That's always the most difficult part of these cases because a 12B1 motion is within the full scope of the district court and it can make findings of fact, but 12B6 facts impinge on trial rights and jury rights, and when they overlap, that's a difficult sorting out to do. It seems to me the district court could sort them out, but it's always easy to say that a standing fact also implicates a merits fact.
Yeah.
It gets very close.
It does, Your Honor. And to that point, at which point there's this, intertwining between the standing facts and the merit facts, this court has said at that point, the district court is to assume jurisdiction and then proceed to the 12B6 analysis, not to just sort of dismiss the case in one fell swoop without getting to those facts. And if I can just add one point of clarification, one correction, Your Honor, is that some of these facts are jurisdictional facts. Some of these facts are sort of merits facts. And, I think that at which point that the facts are jurisdictional facts, then yes, those facts can be resolved even at the 12B1 posture. But if they're merits facts, like why the defendant did what they did, why the defendant pulled the course from the shelf, why did the defendant decertify the AP African American Studies course, questions about intent, those are purely...
Those probably are not necessary for deciding
Right.
Standing.
Right.
All right, you had some rebuttal. We'll hear from you on rebuttal.
Great, so unless there are any further questions, I'll.
Mr. Coleman?
Thank you, Your Honor. Good morning. May it please the court. Miles Coleman. I represent both of the defendants' respondents in this case. This court should affirm the ruling below for either one of two reasons. First, the district court correctly concluded that the defendant's actions challenged in this lawsuit rested on two independent, concurrent justifications, and the plaintiffs only challenged one of them. Second, more broadly, the plaintiffs have even more fundamental standing problems. And Judge Agee, this goes to some of the questions you were asking, which I'd be happy to engage with as well in my time. But let me start with the first and simpler question that's before the court. It's a question of redressability, merely one prong of the standing analysis. Again, each of the two challenged actions, one, the removal of the AP AAS course code, and secondly, Lexington 3 School District's removal of the book stamp. Each of those rested on two separate, independent, sufficient justifications, and plaintiffs have only challenged one of them, the budget proviso. Even if, Judge Leidenblow, even if this court were to agree with the plaintiffs and grant relief on the budget proviso, that doesn't change the fact that an independent, concurrent, sufficient justification still exists that would lead to the same outcome. It would lead to the same result.
How does that square with the Supreme Court's decision in Gutierrez?
So, Your Honor, in Gutierrez and, excuse me, in Long, and in other cases that discuss what I'm phrasing the one obstacle theory, the removal of one obstacle being sufficient to provide redressability. In each of those cases, the obstacles were sequential. They involve future potential, in some cases, potential unknown challenges that could arise. They're thinking that, well, if we eliminate one obstacle, the agency, the government could raise another one. In that case, sure, we can see how eliminating one gets you a little closer to the finish line.
But the plaintiffs here also say that the second reason, that there's a pedagogical reason, that there's a review committee, that none of those actions had been completed at the time of the decision, and they represented here today, they're still not complete. So it seems like that's a contested assertion. And if that's not resolved definitively, and that there's no contest as to that, for standing purposes, how can we consider that?
Your Honor, I don't think there's a I don't think there's a dispute that in the case of the AP African American Studies class, that the recurring periodic review of the social studies standards is still ongoing. But that doesn't change the fact that's relevant here, which is the plaintiffs in their complaint didn't challenge that basis. They never asserted that it was legal.
But why would they need to? They say it's pretext. They say that it's not accurate. What else would they need to say?
Your Honor, in the complaint, they didn't say those things. Nowhere in the complaint do plaintiffs allege that justification was pretextual, a sham, was a cover-up, was legally wrongful.
They don't need to say it in the complaint. I mean, the whole record, this is a large record, and the court can consider the whole record on a motion, on 12B1 motion.
It can, Your Honor, but even so, their standing has to be, Lujan, right, and numerous other cases, standing is determined from the pleadings of the complaint. And if they haven't challenged one of these bases, it's not.
My point is they're not restricted to the complaint. As a matter of fact, it is one of the parties talked about this being a facial challenge, which is totally silly, because a facial challenge is a misnomer, but a facial challenge is a challenge where you rely on the complaint itself for lack of jurisdiction. Somebody didn't allege diversity, or somebody failed to allege the membership of an LLC or something like that. On the face of the complaint, that has to be dismissed. that's a facial challenge. But when you go and look at affidavits and documents and depositions and conflicting affidavits, so long as it's not a merits fact, the district court can resolve all those facts and decide the standing issue. And so the complaint could be totally disregarded. It could be totally compromised by affidavits of the parties. There are, what are there, a dozen affidavits in this case, back and forth, back and forth? It's the district court's allowed to sort those out on a 12b-6, not on the, that's the tough part that I just took up with your colleague, is that some of these facts may be relevant to the merits, and a preliminary decision cannot preempt those facts.
That's right, Your Honor, and it may be helpful. I can point you to a case, two cases, in fact, from this court. As is sometimes the case, these are cases we didn't cite in our briefing, and I've uncovered them preparing for the argument, but that I think are relevant to that question and to the question before the court of redressability. The first is Covenant Media of South Carolina versus City of Charleston. It's a Fourth Circuit case from 2007. Like this case, it's a First Amendment case. Like this case, there were multiple concurrent bases for the governmental entity's decision. And like this case, the plaintiff didn't challenge all of them.
So is this a standing decision you're citing to us, or a 12b-6?
It was a standing decision, Your Honor, and
And it obviously preceded Gutierrez.
it did. But respectfully, Your Honor, that would make no difference, because again, Gutierrez, Long, and the one obstacle cases involved sequential, multiple challenges. You get over one, maybe there will be another one. But this case, just like Covenant, and unlike Gutierrez, doesn't involve multiple sequential, future, hypothetical, potential challenges. It's simultaneous, independent, concurrent bases. Unlike in Gutierrez or Long, we don't have to wonder, if we eliminate one obstacle, would another one arise? Would it stop the plaintiff's desired relief?
So, but why isn't this other reasons, there's a pedagogical basis to remove the course or to remove the book, why isn't that a 12b-6 determination and not a standing determination?
Well, it goes to standing, Your Honor, obviously because of redressability, that even if the relief sought regarding the budget proviso were granted, this independent, unchallenged justification exists. So I think it could go to both, but I think it has relevance to the standing analysis as well.
Well, if we conclude that that is a challenged basis, what are we to do with it at that point? And the district court was wrong that it said it was not challenged.
If, without conceding, but if you were to conclude that it were challenged, then I think the appropriate remedy, as it seems the court has already intimated, would be to remand for Judge Leiden to consider the other arguments at the motion to dismiss stage that haven't been ruled on yet. We cite a number of cases in our briefing in support of that proposition.
And I take it you agree with counsel. The only thing we're dealing with here today is standing.
That's right, Your Honor.
Okay.
That's right, and I agree with that, and of course, standing includes a number of different elements to it. One that we haven't mentioned yet is there can be no standing, at least for the student plaintiffs, without concluding that they have a constitutional right to receive information. That's what the First Amendment claims rely on. And if there is no such right, it's not just that they don't have
For
standing.
standing purposes, isn't the court to, I mean, if it's well pleaded and it's not clearly frivolous, aren't they to assume that at the standing stage?
So to be clear,
They've asserted the right, and then the court could very well make that determination at 12b-6, but why is it entitled to make that determination at 12b-1 or 2?
well, Your Honor, the Supreme Court in McConnell versus FEC did just that, found that the asserted right on which the claim was founded didn't exist, and on a standing basis then. Because if there is no legally cognizable right, there can be no deprivation of the right. If there's no deprivation, there can be no injury, no standing. So I think if there is no cognizable right on which the claim is founded, you can think of it in terms of standing. Other courts have thought of it in terms of subject matter jurisdiction, 12b-1. But it's not just that these plaintiffs, under these facts, don't have standing. if there's no cognizable right, no plaintiff could have standing. So that's an additional basis raised below. Judge Lyden didn't rely on it, but this court, of course, could to affirm the decision below.
All right, well, let me ask you as to student AG. If student AG was a plaintiff in his or her own right, would you agree that that student has standing?
I would not, Your Honor. And if we
Right,
focus,
why not?
if we focus particularly, I think, correct me if I'm wrong, I think particularly what you're thinking of is the injury prong of the standing analysis. AG gets closer, but not close enough, and here's why. AG is a student in a school district that even without the AP class still offers this content as an honors class. It's still available to AG, just not under the AP designation.
Now, plaintiffs contest that as not being factually equivalent, which may or may not be true, but again, why is that a standing decision instead of a 12B6 decision?
Because if there's no injury, right, if the plaintiff still has access to the content that they claim to seek, then they haven't been injured, and that's, of course, a standing analysis.
Counsel, you're arguing that that's the equivalent, the newly baked honors program is the same as the AP?
So a few points in response, Your Honor. The honors class wasn't, I hesitate only because I don't want to overstate from the record. I think it's safe to say the honors class was not newly made to compensate. I think it pre-existed. This AP class is actually quite recent.
You think it is? And again, these facts are always swirling about. Does it exist now? It doesn't, right? The honors program you're talking about. For
The
AP.
honors program does.
Okay.
It's offered
All right,
in that
it's-
school district.
And it's offered?
It is.
And you're saying it's the equivalent?
Right.
How could it be? Isn't that the argument saying it was made in Sweat, and Painter, and McLaurin, those cases that they're saying, well, you know, it's a law school for black people, and we just started it. And the Supreme Court made it clear it's not the equivalent. In terms of AP has a lot of gravitas to it, doesn't it? It comes with a lot of honors and prestige, right? AP class, right? I mean, I'm not putting you in terms, but as a parent, I mean, I know about AP classes. Yes, you get credit in college and those kind of things, and it comes with a lot of gravitas for a student. So how could that be equivalent? And if it is, that's a factual question, isn't it?
So a few points in response, Your Honor. There could be factual questions, but we don't even need to get to those today, because the premise of the question shifts the alleged right, the alleged injury from what's actually pled, right? Because what's pled is an alleged right to receive content, certain information. But the argument that the other side has made and that you're asking about actually shifts what's being alleged as the right. It's no longer the right to receive the content, the information, which is available. Now it's become an alleged constitutional right to get a potential higher GPA that's available in an AP class, or the right perhaps to take the AP exam, which incidentally they can. Students in the honors class can still take the AP exam. They can still get the same college credit. All that's in the record. So really, at that point, what's left?
So we're supposed to accept that as true at this stage for standing. Everything you said is in the record. That means true?
It means for this stage we'll accept it as true.
If the district court found it as true. District court's allowed to make that finding a fact. And if the court didn't make it, then we should give it a chance to make it. But these are facts if it's with respect to standing. I understood the claim to be the loss of content, not the deprivation of the value of the AP versus honors.
I agree on that point, Your Honor. And perhaps I wasn't as clear as I could have been. I don't disagree with anything you just said. I guess what I was trying to say was a different variation on that, which is even without a finding of fact below, even without a factual conclusion, even if we assume the allegations of the complaint to be true, we would still get to the same place, right? Because the allegations of the complaint and the materials expressly cited in it demonstrate to us, they say, and we'll take it as true, that these students in the honors class can take the AP exam, that they can get the college credit for it. Even if there were a constitutional right to take an AP class, which there's not, but even if there were, They're getting the same
We're
benefits.
making the finding in the first instance that there's this equivalence, and I don't think we can do that. District court hadn't done it.
And Your Honor, I don't think you need to make that finding. Again, I think we can look merely at what's the alleged deprivation, even assuming that there's a cognizable right. What's the alleged deprivation? Access to the content. What do the plaintiffs still have access to? That content,
That goes
AG
to
and
injury,
JS.
doesn't it?
That's right, Your Honor. And if they still have access to it, they're not injured, they have no standing. And again, that's aside from the redressability question that Judge Leiden relied on below. I think before I want to move on and mention a few other things and respond to a few other questions, but one final comment. Judge Agee, you I think drilled down a bit on the NAACP as an organization, its ability to assert claims on behalf of its members. I would just point out in the complaint itself, the only thing that's alleged, and this is an amended complaint, mind you, they had a second chance to beef it up. In the amended complaint, the only thing alleged on behalf of the NAACP is that it has unidentified student members who are now unable to take the class. It's not until we get outside of the complaint, as we've discussed, that we get some declaration saying that there's one student, AG, I think, who had intended to. But again, in her school district, still has access to that content. And let's pivot, if we can, briefly to Plaintiff Kendi, Ibram Kendi. We haven't talked about him yet. The same redressability issue there. Now we're moving to the library aspect of the case, his book being removed from the library. He's got the same redressability problem, and then more broadly, some of the same or similar standing problems. The removal of his book was expressly justified. We don't have to wonder. We don't have to speculate about what the motivations were of the committee that recommended the removal of his book. They told us right there in the record. It was because of factual errors and omissions. It wasn't due to viewpoint discriminatory reasons. It wasn't due to partisan bias. It wasn't due to the budget proviso. And even if it were, even if we assume that the budget proviso may have been in the back of their minds, they've given us an alternative, independent, concurrent, sufficient basis for the removal that hasn't been challenged.
I thought you pled somewhere or argued, and maybe it was in a declaration, that basis was a pretext.
Your Honor, I don't want to overstate. I don't think that there was ever an allegation of pretext. Now, I don't want to say that too definitively because there were a dozen or so. There were quite a few declarations. But I don't believe it was challenged. I don't think it's necessary to make a finding of fact or to make a decision at this stage of whether it was a good faith motivation or not. He's got some other standing problems too. For one, that there's no constitutional right for an author to have his book placed into or retained in a public library or a public school library. He's got a problem too that he's alleged his injury has to do with the removal of his books and his viewpoints from the school library, but that's not true either. At all times, before, during, after, and still today, he has books about race and racism in America that are still in that library. He hasn't been discriminated against or excluded on the basis of his viewpoints because he's still there. He's still got those books.
So that's the one book that found to be offensive to the proviso? What is it?
It was the one book that the review committee found contained numerous factual errors or omissions or distortions.
Can you name one of the errors?
I can, Your Honor, though this may be going a bit out, it's going outside of the complaint.
But you just burlesque all these allegations.
What was the error you wanted to address?
In the book Stamped?
Yeah.
So, for example, and there's a number, but to give you a few, the book Stamped states that Ronald Reagan's economic policies caused an increase in the unemployment rate among African Americans. And that is factually, verifiably, empirically untrue. It states that the use of the term crack baby was coined, I can't remember who it says first used the term, but it was coined in an invidious racist sense. And that too is empirically, verifiably not true.
So
There's
now, what's all that have to do with standing?
the nexus to standing is that the review committee had and asserted a non-viewpoint discriminatory basis for its removal of that book, apart from the budget proviso. And the only relief,
Well, again, why isn't that a 12B6 decision to be made? Why are you making that on, it just seems like to me the whole thing's got bollocksed up between the standing inquiry and the failure to state a claim inquiry.
Your Honor, I have 3 seconds left. If I can answer the question, and happy to answer any
Yes,
others.
please answer this question.
Thank you. Now I've got to remember the question. I distracted myself. The relevance to the 12B1 inquiry is that the relief requested has to do only with the budget proviso. Even if the court were to grant that relief, it wouldn't change the outcome and it wouldn't redress the injury. Your Honor, I'm out of time. Thank you.
Yeah, thank you. All right, Mr. McLaurin?
Your Honor, just a few broad bucket points. I just need to clear up some factual inaccuracies. First and foremost, the student plaintiffs have vehemently challenged the alternative justifications throughout this litigation. So, for example, they point to the fact that the sequencing and timing of the purported social studies standards obstacle is inherently suspicious, given that it's not expected to begin until the fall of 2025, which is a year and a half after the defendants pulled the course, and the standards aren't expected to be implemented until 2027. That's 3 years after the removal decision was made. And there's plenty of allegations in the complaint that sort of point out that those, that absurd time gap is in and of itself indicative of this being a pretextual justification that was just sort of thrown at the wall to defeat standing. So the notion that we have not challenged these alternative justifications is just not factual. That's the same mistake that the district court made, and this court should not repeat that mistake. And the same thing for Dr. Kendi. He has vehemently challenged the assertion that his book is replete with factual inaccuracies. So to say that we have not challenged that is just not true. That's been challenged ad nauseum throughout this litigation, and it's been challenged in the briefing filed with this court, with the briefing filed with the district court. That's been sort of a theme, I might add, in the plaintiff's pleadings. The second point is the notion that these purported obstacles are independent. That's also not true, and in fact, the plaintiffs have argued that the social studies standards story that's been put forth by the defendant is really part and parcel of the defendant's general scheme to suppress disfavored viewpoints in K-12 classrooms. And it's really impossible for any court to disentangle that, from the budget proviso. So the notion that these are independent barriers or independent obstacles, that's just not true. The next point I'd like to make is that—
It's not true. You mean factually not true or not theoretically a basis? In other words,
Yeah.
it seems to me to prove redressability understanding, if in fact it was found that the book was removed only because of its errors, not only, but it was removed because of its errors, it seems to me there would be no redressability to give standing on that.
Well, Your Honor, our point is that that's a disputed fact. Why the book was
I know,
removed
but
goes to intent.
But that is something that the district court should have found if it didn't find implicitly, but it seems to me the court didn't fully understand its role on a 12B1. It has to find facts. It has to decide whether it has the power to handle the case. And that's a pretty important requirement, a gate requirement under Steel Company. And so whether it did that adequately, we addressed originally during your argument, was maybe there's more to be done.
Well, I see I'm out of time. If I can respond, Your Honor. Well, at the pleading stage, Your Honor—
Well, it's more than the pleading stage. We're way beyond the pleading. We have, when you file a motion in a court and you support it with documents and affidavits and argument, 4 hours of argument, 800 pages of record, This is not a pleading. This is a motion supported by evidence, and the court, under a 12b1, has to find facts to decide whether it has the power. The only catch, and it's a big catch, and that is when those facts overlap with the merits, 12b6, then we have to be cautious not to preempt jury rights.
Exactly right, Your Honor. And it is a big catch, and that's the catch that's at issue
Well, that's
here
fair,
because,
very fair, yeah.
because again, so these questions as to why the committee removed the book, that goes to the defendant's intent, right? That's not a question that's amenable to resolution on a 12b1. So I agree with Your Honor that at which point that we're dealing with merits questions, not jurisdictional facts. The district court at that point was obligated to assume jurisdiction and then proceed to the 12b6. So unless there are any further questions, we'd ask the court to
Thank you.
reverse
You're
to
going to
the.
send us a 28J letter on student JS.
Yes, we'd be happy to.
Congratulations.
All right.
Yeah.
All right, thank you.
Thank you, Your Honors.
And copy the other side, of course. All right, we'll come down and greet counsel and proceed on to the next case. All right, next case we hear this morning is United States versus Giannone. And I guess, Mr. Kendrick, you're up first.
Yes, Your Honor, may it please the court. I'm here on behalf of Mr. Giannone, who's also here with us this morning. And this is an appeal from the denial of a writ of error coram nobis. And this court has in recent years, in recent panels, recognized that the duty in these cases, in part, is to ferret out and vacate improper convictions, and that is a sacred duty of the courts. What has happened in Mr. Giannone's case is that time has revealed the case is not what the government made it out to be, but it has been a slow revelation. And I think
It seems to me everything you've raised was things that could have been raised during the trial or in habeas.
That's incorrect, Your Honor, and the reason that's incorrect is because the evidence that would have founded the questions that would have needed to be raised was long after both of those proceedings. So we've brought up 4 categories of evidence, but I will concede that really 2 of them I think are very important, and the other 2 add some context as to how this would have mattered in the course of a trial. But the fact that this computer was hacked, and you have to step back to the facts of the case, this was a little bit of a unique way to prosecute.
It was hacked after much of the critical evidence was already taken off.
I don't know if that's clear, Your Honor, and the reason...
Well, that's what the record seems to show.
Well, but that's the problem, and that's the problem with a Brady issue, is that
what you're doing here, we have a 2007 judgment, and here we are in 2026, and raising issues for the first time, and you want the judgment set. What do you want, actually, in this case? What is your relief?
Your Honor, obviously, we would love for you to grant the writ, but I think the relief...
No, I'm asking what the relief. If we grant coram nobis, what do you want?
Well, it would vacate the conviction, Your Honor.
So he just goes off scot-free, huh?
Well, Your Honor, I think that matters in a Brady case
And
because
you've established innocence in this case?
I think we have. But I don't know that and let me not overstate that, Your Honor, because I don't think I have to establish innocence.
You need to establish a fundamental right, and the one
Right.
place that we have granted it is where somebody was wrongfully convicted. And it was pretty clear that the judgment had to be set aside. But when you have errors of the type that you're raising, which are almost all evidentiary or incompletions of evidence, if you want to say that, basically, that still doesn't say you were innocent, your client was innocent. What it says is that maybe some errors were committed. But coram nobis is a very rare bird. And we have the doctrines of finality, appeal, and then we have the collateral review under habeas. It seems to me you have to make a pretty strong case that your man was innocent in order to get the conviction set aside, don't you?
No, I don't agree with that. Let me walk through why I think that, Your Honor. So Lassane, which is one of the more recent leading cases, was a legal innocence case. So it wasn't necessarily a wrongful conviction. It was simply just that the law had changed. The other cases, Akinsadi, which is another leading case, was actually an ineffective assistance of counsel case. It was fairly routine.
Yeah, but if you have something structural,
Right.
it seems to me it gets pretty fundamental. I mean, if you have a judge that it later turns out was on the take and the other side had paid him off, it seems to me that's pretty structural. And would be subject that might satisfy the fundamental requirement under coram nobis. But all right, go ahead. I didn't mean to.
No, Your Honor, and listen, those are good questions, and I think they need to be addressed, because what we haven't seen in the history of these cases, if they've progressed through the more recent Fourth Circuit opinions, is a clear Brady violation. And in this case, the reason I would disagree with the first premise that you made about these things could have been raised is that the record is replete with instances in the trial where the government is saying there is a star witness in this case, and it is this computer, and it is these chat logs, and it is unimpeachable. And that is what he frames to the jury. Days after the trial, the letter arrives from the confidential informant undermining those claims with this computer hack information. And Mr. Giannone raises that.
So do you dispute that the hack occurred after the acts for which the defendant was charged?
I dispute that we know that's the case, Your Honor, and the reason is because that comes from an affidavit from a Secret Service agent who is revealing what he needs to reveal as slowly as he can. So in the trial, he never says a word about it, and he in fact makes some affirmative, in other ways, affirmative statements that turn out later to be impossible. So I don't know that we have that information because and again, the timeline matters because Mr. Giannone raises this in the motion for new trial. He raises it in this court on direct appeal. He starts to bring it up in 2255, but I think recognizes that he still doesn't have any new information, and this court has spoken on the Brady violation. So as he enters the FOIA litigation from federal prison, he begins to receive documents. And years after he has, to some degree, given up on this claim, he finds this report that is in the record that this man who said he hacked the computer is a very well-known and famous hacker, Secret Service.
He received the FOIA in, what, 2018?
It was before that, Your Honor. I mean, he received it, I think there's some slight dispute, but I will say it appears that it was
2016, when did he?
around 2015 or 2016.
Okay, he received the FOIA documents.
Right.
And here we are in 2026. That's
Correct. And Your Honor, I think it matters, the timeliness, I think, matters in two places. So first of all, that I do think there's a fundamental
Well, the
problem.
district court gave one reason in this case was that the filing was simply untimely without sufficient explanation.
Right.
What's wrong with that?
Well, because I think if we look at the time, number one, he's not privy to this information. The earliest date, even if we give the government credit, they say 2015, they think he might have received these documents, but he receives thousands of documents. And you can look at what he received in the record. This is not necessarily the memorandum of interview or the DEA 6 reports that we're used to seeing that are clean, clear, very subject.
give him a full year to read every day he's in prison, to read all those documents. It seems to me, if he didn't get a suspicion then, I mean, we're talking about, what, 10 years later?
At the time that he gets these, Your Honor, I think he
8 years later.
Sure, but even if he gets them in prison, he's trying to go through this, and he's out of prison, and he's trying to rebuild his life after prison. He's being put on notice, or not put on notice, but you're putting a responsibility on him that he would need to understand how all this contextually mattered to his trial, and then understand he immediately needed to move for extraordinary relief. There's been some criticism of the fact that he took his complaint to the Office of Professional Responsibility of the Department of Justice, but that makes sense when we look at the circumstances, and some of the cases talk about the real-life circumstances of these people raising these claims, that he has gone to the Department of Justice and said, look, I have found this information that disputes what you said at the trial, what you said in post-conviction proceedings, what you've said in sworn affidavits, and I'm asking you to make a finding for me to help me. And what they come back with, we can't do that. And you're right, there is a delay where not much happens, but I think it's telling that when he does retain counsel, it's around the same time that Lassane comes out. This is, like you said, a rare bird, Your Honor, so I think that it would be too high of a burden to look at a convicted defendant and say, you need to know that you need to raise a coram nobis at the earliest possible point you can raise it. And that actually isn't what the law says. I recognize that one of the mistakes in Sutherland, which this panel heard, was that they just said, well, there's no limit, so we're not bound by anything. I don't make that strong of an argument. What I think we have to do.
You know, when I went through the record, your briefs and the arguments in the record, there is statement after statement that he makes relating to whether something was true or untrue that is palpably untrue. For instance, he talks about a bank account that was withdrawn in San Francisco, and he was in New York. Ergo, it was not him that withdrew it. Yet, number one, he admits by stipulation it was his bank account, and number two, he withdrew it through an ATM in New York. Now, to me, it just doesn't hold water. He's just making up arguments which don't even hold water today. Wouldn't have held water then. The other argument he makes, he said, my travel showed I was innocent because the car I rented was in another name. Yet he admits that he used fraudulent names in renting cars. I mean, you go through one thing after the other. The same thing with the trace and the computer. The evidence was that the hack was on a given date, and yet all the critical evidence came from the computer earlier. These things are arguments about evidence, but they're not even legitimate arguments. It seems to me his innocence does not show through at all. This man manipulated things and bragged about it and stipulated that this was his account, and he withdrew money from the fraudulent received sums. And
Your Honor, I don't agree that these are made-up arguments, and I have to.
You don't agree?
I do not agree they're made-up arguments. The four classifications of evidence.
How can he make an argument now, 20 years after judgment, 10 years after he gets the FOIA documents, that that was not his money withdrawn from San Francisco? That is in the briefs now.
But Your Honor, but I did not lead with those because I will agree that those are my weaker claims, but I think that it's playing with fire to not raise everything I can in a coram nobis. But the two things that...
You can't even raise it because it's illegitimate and it was decided by a jury. But the fact is, the reasons he argues that it was illegitimate at the time from the FOIA documents is just, it's an assumption that you can't withdraw money from a bank in San Francisco while you're in New York. And that's what argument he makes. I could not have rented that car because it was in a different name, yet he brags that he was there. His travel shows he was in a particular city, and he brags about renting cars in other names. This type of stuff is not innocence.
But let me let me put something out there. So during the trial at the record, I think it's JA 247. There is testimony from the Secret Service agent who says, we have no way of determining the location of the parties that are making any of these communications. Is what he says under oath. And years later, what we find is this trap and trace record that you just mentioned that shows locations. Now, trap and trace works, interestingly, differently when you're talking about instant messaging.
So how does that contribute? It doesn't contribute at all to innocence. They have all the transactions and emails. I mean, the evidence is, I think, is pretty pretty solid. The jury got it right, and you want us to say, based on these evidentiary retwists or re-arguments, I still don't understand why the location helps you a bit.
Because, Your Honor, part of this matter is who is where when these communications are happening. We don't know that this is Mr. Giannone making these conversations. What they're doing is trying to match it to other events. And the two things that matter, they keep saying these chat logs are unimpeachable. I cannot agree with you that knowing later that the computer had been hacked and no one brought it
They had
up.
about half a dozen different evidentiary matters to demonstrate that it was him, that was the call he used, that he used it, and that those were, I mean, I don't want to re-argue the thing. I'm going to the point that really what you're raising are some evidentiary points that maybe could have been argued differently. I don't think it gains you anything, but here we are, 20 years later. The district court said it was 8 years after you got the FOIA documents and said you sat on those rights. There's a aspect of latches. It has to be timely. And the district court relied on that heavily, didn't he? Said that was 8 years was too long to sit on it.
And if I could just address one point,
Yes.
my time's out and I have time on
Go
rebuttal
ahead.
to talk. But I do not agree that this is an evidentiary matter that we are retwisting. These are things that were not known to him
No, my
at the
question
time of
was,
trial.
isn't the main reliance was the district court saying this wasn't timely?
Right, and I think the timely
Wasn't
does,
explained.
but it does matter with the fundamental. And I think what Your Honor is questioning me about is whether these are fundamental errors. And I do not agree that these are simply evidentiary matters because no one knew about them. At the trial, these were unknown events. So, and I'll address that later on rebuttal. I don't want to take up more of my time. Thank you, Your Honor.
All right, Ms. Hoffman.
Good morning, Your Honors. Andrea Hoffman on behalf of the United States. As the court was just discussing, the primary issue underneath at the district court was the timeliness or lack thereof, as we should say. There are two different grounds on which this court could affirm the dismissal. One, but the other, we have not yet discussed today, is that the defendant is presuming that there was a discovery error. He has never established that there was a discovery error, that these materials were not produced. And as this court found,
I'm sorry, that the what wasn't produced?
that all of the materials in the FOIA
Oh, okay. I
record
just didn't understand.
weren't produced. As this court found in Rocky Mountain, U.S. versus Rocky Mountain, and as the Supreme Court found in U.S. versus Morgan, there's a presumption that the underlying proceedings were correctly handled, and it's the burden upon the defendant to establish that there was some sort of error. His mere assertions or allegations that he didn't receive these records are insufficient on its face to support that or establish that point for the record. So this court could dismiss it on that ground alone, since as under this court's established law, such as Scott, you can affirm on any reason that's within the record. But setting that one aside as an unproven fact, mere allegations out there, there's also the timeliness issue. The district court found plainly that there were two periods of time at minimum in this, as the court has recognized, nearly 20 years worth of time that has passed since this conviction occurred that have unexplained or unjustified explanations for the lengthy delay. And frankly, there is still no reasons that have been provided that are worthy of finding that any kind of delay or the extent of this delay is justified. No sound reasons have been put forward for the wait between 2008 when the first FOIA request was filed and 2012 when the next, 2014 when the next FOIA request was filed. A 2-year gap after he received the first records, Your Honor, in 2012, according to the filed pleadings in that FOIA proceeding. The next records were received in 2015. There is then a 4-year delay before the OPR complaint. There's then another, quick math, sorry, 3-year delay before counsel's retained, and another 2-year delay before the quorum novus proceeding has been filed. all of without an explanation. To argue that this is a pro se defendant or complexity of the documents would open the door to nearly every defendant that ever seeks a FOIA request having grounds to be able to raise a quorum nobis petition, something that the Supreme Court and this court have been very clear is an extraordinary, rare beast, one that should happen. The Supreme Court has gone so far as to say they can't even necessarily envision circumstances warranting it in this day and age. I think Judge Niemeyer obviously has nailed the most obvious one: when the law changes, when you are no longer legally guilty of something because the acts are no longer considered criminal, something's been reversed, those kinds of circumstances are unique. This is not that. Nor is this, if I turn to the merits of the issues, one other point before I move on the timeliness. Partially, we know that he could have done it earlier because he did file the first FOIA request in 2008, and he did file the FOIA complaint. So he's chosen not to take other actions, not been unable to do so. Turning to the merits of this matter for a brief moment, there are a couple of underlying pinnings. The question here is whether the district court's rulings are plausible on the face of the whole record. And in a Brady context, there would be no Brady violation where the defendant had access to.
If we were to agree with you on the timeliness basis, we would not need to go any further.
No, sir. No, sir. And if the court had no questions about the merits, I would sit down as opposed to take your time, but if I would be happy to address any of the merits issues so that I can clarify anything for the record.
Anything further? It's up to you.
I'll give a brief snap on this, tap on it. On the issue of the chat transcripts and the integrity of the documents, these records were produced at a simultaneous screen recording of everything that was occurring, as well as a simultaneous verbatim translation, a keystroke logger system, by the federal government at the time that the records were completed. The integrity of them have not been challenged because they can't be. During the trial, they were playing simultaneous pieces of these to show the integrity. There's no question that the transcripts in May and June of 2005 were not altered. There's no question that there is the stipulation that the court recognized. So the criminal conduct was established through the stipulation and the chat transcripts. All of the various other pieces of evidence that defense counsel is talking about were corroboration of Mr. Giannone's identity as the actor in those circumstances. The first piece of evidence proving that.
It seems to me that goes away immediately when the undercover agent gives him $500 and he deposits it in a bank account. And it turns out at trial he admits that was my bank account. It seems to me that ends the case.
I do not disagree, Your Honor, and then that's bolstered by two witnesses that came in and personally identified him as someone they know who utilized the chat names that were at issue here. So all of the rest of these records cannot rise to a level of fundamental because they were corroboration solely of, even if we accept for a moment that errors happened, that they were material. I'm just going to set that aside for a moment. They cannot rise to the level of a fundamental error because they were mere corroboration of the personal identification by two witnesses and his own stipulation that established his identity as an actor in this criminal conduct. Thank you very much, Your Honors. I will ask that you affirm the district court's findings.
All right, thank you, Ms. Hoffman. All right, Mr. Kendrick.
Your Honor, if I can address a couple of points, because I don't think that, I can see this is a difficult case, and I understand your concern with it, but I think that when you say, the case is over when he withdraws this money from this account, first of all, 600.
No, it didn't, the case isn't over. What I'm saying is he says his basic argument is that it was not me. I forgot his name on the, alleged name on the internet. But he says that was not me. But the undercover agent is dealing with that person, gives that person $500. That person deposits it in a bank in San Francisco and then withdraws money from it at an ATM in New York. This man says that was my account. Now, isn't that a direct link and admission that that person is me?
I don't agree that's how it happens, Your Honor. What happens
That's
is
what I saw on the record.
there's bank account information given to the confidential informant. He sends the money to the bank account, $600. After that, Mr. Giannone agrees he withdrew $500 from this ATM in New York City. That isn't some smoking gun that there's no possible way there
No, but it
because
identifies him because the undercover agent was dealing with a person purported to be, give me his, the name, internet.
either CI Intel or Pit Boss were the ones
Yeah,
that the
yeah,
defendant
yeah.
was,
They were
claimed were
dealing
his,
with
yes.
that person, gave
Right.
that person, whoever that was, $600.
Right.
So now the question is, who is that person? That person took the $600 and deposited it in San Francisco, and that person withdrew it from an ATM in New York, $500 of it. And that was stipulated.
I don't agree that that's how it happened. What I agree was, I don't agree, I think you were adding the fact in that this person took that money from the undercover and then put it into the bank. That's an extra step. It was the undercover who sent the money to the bank. But let me say this, because I think where I don't agree with Your Honor's position on the case, and I think this is the underlying premise that you would rule against me on, is this idea that these are evidentiary twists that really didn't matter.
No, what
But-
I'm suggesting to you is that there is a requirement, because of this writ is such an extraordinary writ. We only have, we have principles of finality.
Right.
We have a trial, and then we can look at things with habeas. That's an exception. That's a long-standing writ. Quorum nobis is still there for the exceptional circumstance, I think mostly in a circumstance where it's later determined that the man never committed the crime. That is not the way it's defined. It's defined as a fundamental right, and the Supreme Court's made pretty clear it has to be very fundamental.
And that is why what I'm not connecting on is that this is a Brady claim that we are making underlying this case.
You
And the
haven't
problem,
demonstrated they used this evidence at trial. I don't understand.
Your Honor, maybe I'm not clear. Maybe I'm not clearly explaining this, but here's what this is. Very similar to Parker and Bartco. The government stands up with a witness. Now, it happens to be these chat transcripts that they repeatedly say cannot be manipulated. They cannot be impeached. This computer is completely secure. No one ever says, there's nothing about a hack in trial. If Your Honor is correct on the timing, then they certainly, by trial, knew that the hack had occurred. And that's actually at 406 of the joint appendix or thereabouts, or the reports we rely on, where they've gone to this man who is kind of minimizing what he did, because it's a little bit unique to use a Netflix transcript as part of evidence, but there's a clear story about what Mr. Lichtenstein was doing. He is one of the most skilled hackers in the world, responsible in part for this $1 billion hack of Bitcoin. This is a man who knows how to manipulate a computer. In Parker and in Bartco, one of the central witnesses who established the guilt of the defendant had something impeachable about them. It arguably in both cases wouldn't necessarily have gone to the heart of what the person said. It just called into question how accurate it was. And that is what matters in a Brady violation. And the problem with the timing argument that we're having is that there's going to be situations where Brady is never uncovered. I think we have to understand that statistically it's possible that a Brady violation escapes all notice. But there are going to be plenty of other times when a Brady violation is discovered long after the trial occurs. So specifically what I'm addressing is when you say all of this could have been raised at trial or in post-conviction, here's why we know that's not the case. Because it was raised in post-conviction. But the judge dismissed the concerns because there was nothing to support this idea that there had been any computer hack other than this letter from the confidential informant who was never called at trial. Years later, after the time to bring those had gone, that's when he discovers that in fact the computer was hacked. So not only was the hack something that happened, but there was a detailed report on it. You can also look at page 457 of the joint appendix where during the FOIA litigation, there is a notation that the case agent says, I have the case file, there are sensitive things in it that Mr. Giannone should not see. And I have no idea what that is. But these are the things that I think this has to have a hearing before we dismiss it so out of hand that the government has, I mean, I take issue with the government saying this information was turned over, because if it had been, it looks like from the notes I see in the FOIA response, they would have said, we gave it to you under Rule 16. We don't have to give it to you. This is new information. But it's not just new information. It's new information that directly refutes what the government's agents were saying under oath on the stand. Those locations do matter, because one of the primary things you would do in any trial is say, okay, well, here's all the communications you have. Here's all the cities from which they originated. I can tell you where I was. But because that wasn't known, and they said, we don't have any way of telling where the locations were, that was a worthless defense, because you wouldn't have been able to establish you were somewhere else, because the government did never say where you were. So the location, the trap and trace, and then this hack, I think, are a far bigger deal than we seem to be discussing them as, because they're not just sort of perchance evidentiary issues that got passed over in trial. It is evidence that directly challenged the credibility, the central theme of the government's case. My client never had it. So now he's brought it up. It's a Brady violation, which is fundamental, and I think weighs against timeliness being the sole reason for the dismissal of this petition. Thank you, Your Honors.
All right, thank you. We'll come down to Greek Council and take a short recess.
This honorable court will take a brief recess. Fourth Circuit.
Be seated, please. Next case we'll hear is Kuiper versus Mena, and Mr. Hay, is it? Hay or he?
It's he.
He, thank you, I'm sorry.
No worries at all.
No,
Thanks
it's
for
all right.
asking.
All right, Mr. He, we'll hear from you. It's the worst thing to mispronounce somebody's name, I think.
I could think of worse, and I'm used to it my whole life. May it please the court, Kang He, on behalf of the appellant Mario Alberto Reyes Mena. Mr. Reyes Mena has foreign official immunity for a military operation that was authorized by the Salvadoran government and that took place entirely on Salvadoran soil. In the 1980s, El Salvador reached a breaking point in its nation's history. The country became engulfed in a civil war about the spread of communism, and many countries, including the United States, faced the same problem, and they battled it in their own sovereign ways. In El Salvador, thousands of guerrillas, armed by the Soviet Union, tried to take the country by force. It was a brutal war with armed combatants on both sides, and it was not a conventional war, as the term guerrillas may imply.
But the government of El Salvador has not made a suggestion for immunity in this case.
That's correct, and that's not required, Your Honor, under the case
I
law.
understand, but in fact, they've sought to prosecute your client.
That is correct as well, Your Honor, but there is a difference between what is essentially a merits determination of the issue and the jurisdiction issue that this court's face. Do we let El Salvador handle that matter on its own, or is it for the U.S. courts to interfere with that
No,
process?
I think the point is a factual question. In other words, if you're acting as a sovereign, carrying out military orders, it's one thing as an agent, but factually, if the sovereign says, no, you were not carrying out military orders, that's a factual matter. But there are other facts in this case that we probably ought to look at and then hear what you say about them. But we're talking about unarmed journalists, right?
Your Honor, that's what the other side alleges.
Well, wasn't that found by various inquiries?
Yes, but Your Honor, we're not here to determine what the merits are of this. It's a matter of jurisdiction and
No, but we are interested, I believe, in determining the nature of the conduct, whether it's immune. And if it is a sovereign act, that's one thing. But if it is a at random killing,
Your Honor, it was not.
non-judicial killing, then it may fall within this range of acts that don't constitute sovereign acts.
And Your Honor, a few clarifications. One, El Salvador has not come out and said that the operation was never authorized.
They just don't support.
And just because a new regime that comes in hindsight, decides to launch a prosecution against a prior regime, it doesn't make the conduct itself unofficial. In fact, the complaint pleads facially that this was an official act, that at the time it was authorized and ordered by the Salvadoran government, that the order came from the top echelon, and that this was part of Salvador's military strategy to win its civil war. And that's important because our courts should not be used to judge El Salvador's civil war strategies, much like Salvadoran courts should not judge the military strategies that the Union used to win the American Civil War. Comedy dictates that we allow El Salvador, which Judge Agee did point out, to use its own courts to decide this dispute. And if the United States...
The United States government hasn't made a suggestion of immunity either.
That's correct, Your Honor. They have not, but again, that's not required. In Sementar, the Supreme Court did say, in the absence of a statement of interest, we proceed on whether foreign official immunity exists based on the factors at issue.
So why didn't our decision in USEF control the outcome of this case?
Your Honor, it doesn't control because, and again, USEF did apply a jus cogens exception. First of all, we're not asking the court to overrule USEF, but to recognize it for what it is. It was a common law holding that depends on the facts of the case. And there's 3 reasons why USEF does not govern here. First, USEF involved an official from an unrecognized government, But Mr. Reyes-Mena is from a
The
recognized
court also
government.
said when it addressed that point, that that was an alternative basis for its finding.
Your Honor, it was one in which supported the finding, and I think what matters, though, in any common law holding is we look to the facts. That was the facts that were presented to the court in Yusuf, and that was one of them. The second is that the State Department expressly opposed immunity in Yusuf, and they've not commented here. And the third is that there are substantial comity concerns, especially considering that El Salvador is using its own courts to address this matter. And that underscores.
So is your argument that the jus cogens, if that's how you pronounce it, norm doesn't apply unless there is a country which simply does not have a recognized government, and that that's the only circumstance in which it would apply?
No, Your Honor, we're not asking the court to rule any broader than the facts of this case. We're asking the court to clarify that Yusuf does not apply to the facts here, and it's very different, for example, in what happened in Warfa, where the court was presented with an argument from counsel there that Yusuf controlled, and I believe, Judge Agee, you wrote the opinion in which you said that counsel asked us to overrule Sementar entirely, but that's not what we're doing, asking the court to do here. Besides those communist concerns, there's also a key difference in the conduct that's alleged. In Yusuf, the court had no occasion to consider an authorized military operation involving combatants on both sides.
Well, bottom line, tell me this. After Yusuf and Warfa, is there a jus cogens exception?
I'm sorry, Your Honor, could you repeat the question?
After those cases, does the jus cogens norm apply?
In what sense? In this case or
If there are
generally?
circumstances, is that a valid legal doctrine?
Your Honor, if you're asking me whether I think it's a valid legal doctrine, I don't think so, but the court doesn't have to decide that here today. Again, we're just asking the
We've
court to
already
clarify.
decided it, haven't we?
Excuse me, Your Honor?
Haven't we already made that determination?
The determination was made under the facts of Yusuf. And again, Yusuf there
Well,
dealt.
I'm unclear on the last answer you gave to Judge Agee. Do you disagree that the doctrine exists, jus cogens?
So the doctrine itself, jus cogens, which is just about the norms, there is some existence of that in the world. I believe, like, for example, the United
Are
Nations
you
has
saying
that.
we should not apply it? In other words, I'm not sure what the rules you're advocating here. In other words, if it applies, then there is a list of crimes that have been included under that which are not considered to be sovereign acts.
Right. Your Honor, what I'm saying,
And the DC Circuit listed them, but I think other sources have listed them, as well as international cases. And the question is whether, I mean, you say continuously it's not part of international law in your brief, and yet every case I see says it's part of international law.
Your Honor,
And they actually use that word, international law.
it's not a part of international law in the sense
Where
that
do we get international law?
where Yusuf obtained international law was citations to international cases. It ranged, for example, in the United Kingdom. But if you look at international law and the cases that are cited in our briefs, none of those cases, those international cases, actually support application of a jus cogens exception in a civil case. In the UK, there was a case in which the court said, we will not apply jus cogens here in a civil matter, but there are examples of its application in criminal law. There's examples of its application in international law where the jus cogens conduct occurs within the forum state. And that's a big distinction because, again, it deals with jurisdiction and whether the court, the forum court, has that ability to decide that claim. Congress, too, in the FSIA, which I recognize the FSIA doesn't apply strictly to the foreign officials, but it's important to note the FSIA because foreign officials derive their immunity from the state. And so if the state has that immunity, so too should the foreign officials. And in the FSIA, Congress did not recognize such a
That's too
categorical
general.
exception.
That's too general. I mean, obviously, if they're acting for the sovereign, within the scope of the sovereign acts, as I understand the principle as articulated, is, however we want to say, jus cogens or jus cogens, English or Latin, whatever. It seems to me, if it applies, it basically says an act that is jus cogens is not a sovereign act and therefore not protected. Isn't that what your understanding is?
And Your Honor, it doesn't apply because
No, I'm saying, let's stay with it first as it's understood,
Yes.
wherever it's applied. So if an act is a jus cogens act, then there's no immunity. It's not a sovereign act. It's not a legitimate sovereign act and therefore enjoys immunity.
Well, Your Honor, we believe that's a legal fiction that a sovereign can never authorize a jus cogens or conduct that leads to a jus cogens violation or a jus cogens violation.
Counsel, I don't know that you've answered the fundamental question yet.
I
Do you
do,
believe that the jus cogens norm is a principle of American law?
no, I do not, Your Honor. And the reason why is because if we go through the
So the
co-equal.
decisions that have applied it, in your view, are simply wrong.
Your Honor, I do believe that use of application was wrong, but again, we're not asking the court to overrule it entirely.
I'm having trouble understanding your whole argument then, because either you're arguing jus cogens is not applicable, which I'm now hearing you say, or you say this conduct in this case didn't fall within jus cogens. Cogens. And it seems to me, if jus cogens is an applicable principle, then the question we look at is the nature of the conduct here to see whether it falls within it, and therefore immunity is joint. But if it doesn't exist at all, I think I missed that a little bit then, that you think it's not a proper principle of American law. And of course, we have cases that have applied. The DC Circuit and our court have both recognized it, right?
I don't believe the DC Circuit has recognized a jus cogens exception. I think it's important to note that when the use of court recognized it, it was done in the context where there was no recognized government, there was no comity to be given.
Let's step back then. What is your argument on appeal? Your argument on appeal, there is no such doctrine and therefore it should not have been applied? Or is your argument that the conduct in this case did not fit it?
Your Honor, our argument is more so the former, but to clarify, we're not asking the court to overrule USIF. It's that the jus cogens exception that was applied in USIF does not apply to the facts here. And a big part of that are the comity concerns. When the USIF court applied it, there was no comity owed to the Somali government, but there is a comity interest here, and comity dictates that we allow El Salvador.
So your view of that is that the jus cogens only applies when there are acts in a country which has no recognized government?
That would be USIF, right, Your Honor? No recognized
I mean, is
government,
that
no
your-
comity
Is that your
owed.
position or not?
Yes, Your Honor.
And where do you get that, where do you find support for that it's limited, so limited?
We-
Except for it's a particular application in the one case.
Right. Your Honor, and I wish the opinion had been more clear as to it, but the principle I draw upon is just the notion of common law holdings and how they develop incrementally based on the facts of the case. It's not uncommon for this court and other courts to revisit prior decisions and make clarifications.
Oh, no, I understand that, but I'm trying to, I'm having difficulty in understanding what principles we ought to be applying. And you're basically saying jus cogens is foreign to this case. We shouldn't be applying it at all. It's legally wrong to apply it.
Yeah, it would be wrong to apply to the facts of this case, Your
And
Honor.
the facts of this case are, the distinguishing facts of this case is that there was no government in control versus a government in control? Is that the issue?
Right, it's the difference between an unrecognized government and a recognized government, but also the events that allegedly occurred. When we talk about USIF, it was an alleged genocide. It wasn't a situation.
Well, now that you're going to facts, I want to still stay a little bit with what we're supposed to be applying. And so you're basically saying there's no doctrine to apply and we should throw it out. There's no law supporting it in a case where there's a sovereign.
That's correct.
Even though the sovereign in this case disowned the conduct.
Your Honor, the sovereign in this case did not disown the conduct. Right? They've never said this was never authorized by the sovereign. And it's a situation.
As
in-
a sovereign act, I'm talking.
It was a sovereign act, Your Honor. It was a sovereign act. The other side has pled it. And El Salvador has not come out and said otherwise. Yes, they have prosecuted for it, but it doesn't render what occurred a sovereign act. It just so happens, and if you look back at history, there are many instances of sovereign acts that occur in which, for example, the use of Agent Orange in Vietnam, now banned. Also, the use of chemical weapons in World War I, now banned. Those are still sovereign acts.
Coggins includes, as articulated by some courts, includes, for instance, slavery, includes non-judicial killings, which is the issue here. Now, a non-judicial killing means without any hearing, without any, you just shoot. The question is that recognized as a sovereign act, even though the sovereign orders it? And the principle, as I understand it, is not.
Your Honor,
You can try to extend it to other things where sovereigns act wrongly or do the wrong things, but if you just start shooting people.
Your Honor, I see my time is up. Do you mind if I answer
Oh,
the question?
please answer.
I do believe that if a sovereign does order and authorize it, it is a sovereign act. And that's what we're talking about here, because the other side has not alleged that Mr. Reyes-Mena has acted in his personal capacity or went rogue. He acted under orders of the Salvadoran government during its wartime mission and following its strategies. And that's why the court should clarify use of does not apply. Thank you.
All right, Mr. Head?
May it please the court, the sole issue on appeal is whether the defendant is entitled to conduct-based immunity for directing the extrajudicial killing of 4 journalists.
Well, I'm not sure that's the sole issue. I'm very curious to hear what you're going to say about Jus Coggins and whether it should be recognized and what its limits are. Set aside, before we get to the facts of this case.
Of course, Your Honor, and I think this court need not look further than this court's decisions in Yusuf and Warfa, which several years later reaffirmed the holding in Yusuf that in a circumstance where the State Department had not taken a position on immunity, this court said any violation of Jus Coggins norms, including an extrajudicial killing like alleged here, cannot constitute official capacity conduct. And so it's not possible to afford conduct-based immunity to that official. Warfa reaffirmed that holding several years later in an opinion that you authored, Judge Agee, where there was, at the time of that decision, a recognized government in Somalia. And also the State Department had not made any suggestion or any submission at all in Warfa. And so the two primary distinctions that my friend offers of why this court should not apply that precedent from Yusuf and Warfa are squarely answered by Warfa, which is on all fours with this case.
So what would be the difference in this case if the State Department had come in and filed a suggestion of immunity here? How would that change this case?
We would be, sorry, Your Honor. We would be in a very different universe because under the Supreme Court's decision in Samantar, step one is, has the United States suggested immunity? And this court said a few years later in Yusuf, if the United States does that, this court would give substantial weight to the United States' view. That hasn't happened here, and so we're only in the step 2 analysis where the court must independently analyze whether or not the official is entitled to conduct-based immunity. And so there's no question whatsoever of deference to the United States' views.
Now, what about the argument that the doctrine applies only in the criminal context and not civilian?
That's not what, Your Honor, this is a civil case, and that was exactly what Yusuf and Warfa was. They were both involved TVPA claims, which is exactly what's at issue here.
He suggests, I guess, that maybe those are wayward opinions because the international law at best recognizes in a criminal context.
Your Honor, I think the court considered that very issue in 2012 when it decided Yusuf. There is some international law that goes both ways on Jus Coggins norms.
Where do we look for international law?
Sort of the settled principles of international
Well, I
law.
know what they are, but the problem is I hear in the newspapers daily that the notions that the high seas, South China Sea, and that the borders aren't necessarily to be honored. The question is, where do we, it's just an ongoing understanding, and where do we find that understanding?
Well, I think the easy answer in this case is that the court doesn't need to independently analyze international law because the outcome is controlled by Yusuf and by Yusuf and Warfa. And in Yusuf, this court did consider a variety of decisions from the UK courts and other courts, and found that the weight of international law supported this jus cogens norm. And so
Basically, you're suggesting that, and maybe correctly so, that we as a panel don't need to explore that scope because we already have precedent that recognizes it.
that's correct, Your Honor. I also want to just make clear there's no dispute here that these acts, the alleged extrajudicial killing, violate jus cogens norms. And I also want to note that even if this court were disinclined to follow its precedent in Yusuf and Warfa, which of course it should not do, there are alternative grounds here. It cannot be official capacity conduct, factor 2 of the conduct-based immunity test, where the sovereign has not ratified the conduct. There's really no dispute in the record that sitting here today, El Salvador has not ratified this conduct. It is criminally prosecuting Mr. Reyes-Mena in El Salvador. It is seeking his arrest.
The government of El Salvador had filed a motion for the grant of immunity.
I think that would probably go under the step 1 analysis, Your Honor, which is, it ultimately would be about whether the United States, how the United States decided to act. Because as my friend argued, sovereign immunity is a recognition of comity to the foreign state. And so the executive branch would get deference in that circumstance about whether it decided to grant or was disinclined to grant a request of immunity from El Salvador. But the analysis is easier in this case because El Salvador is not saying this is official capacity conduct. Sitting here today, that is clear from the record. My friend also has an argument based on El Salvador's view at the time that this is now a different government and it would be some sort of disrespect to the El Salvador, whether it's sitting here today or the former government. But the allegations in our complaint make clear that this was not just another military operation. Even at the time El Salvador denied the killings took place, they tried to cover it up. They blocked investigations from several governments.
There's no damages claim as to the government of El Salvador.
That is correct, Your Honor. We're seeking damages solely from the personal assets of Mr. Reyes-Mena. So even at the time, and in fact, in the 1980s, El Salvador tried to prosecute Reyes-Mena as well. And it was only because of an amnesty law that El Salvador passed that frustrated that prosecution and has led now to the prosecution taking place today. And so even that argument about, this was official capacity conduct at the time doesn't hold water based on the facts as we have alleged them. And that's at Joint Appendix 25 through 27 and 33. Briefly, I also just want to note that there is no circuit split here. This was a key aspect of my friend's arguments in the brief. And we would submit that the case would come out exactly the same way under either Dogan from the Ninth Circuit or Matar in the Second Circuit. And that is because each of those cases, as well as the Fifth Circuit in a recent case, all recognize that there cannot be official capacity conduct where the foreign government has disavowed the action.
I gather the underlying all of this is a recognition that sovereigns respect each other's sovereignty, and so that the views of the sovereigns themselves are relevant to looking how to treat these things. But it goes further than that, but it seems to me that the State Department's standing and El Salvador's standing to comment relevantly on this type of thing flows from the international relationship, the relationship among sovereigns.
That is correct, Your Honor. It is well recognized since the Schooner exchange from Justice Marshall that sovereignty is an act of recognition from one state to another. And that's what makes this decision an easy one, we would submit, because here, El Salvador...
Well, it starts, at least it gets by the notion that there might be barriers if the two sovereigns here requested immunity or advised immunity. But since both don't, that leaves it more open for the court to look at the conduct and international practices or law. In our case, some precedents.
That is correct, Your Honor. All we have here is the former official himself, who's been out of government for several decades, living comfortably in Virginia. He's the only person asking for immunity in this case, no fellow sovereign. Just to briefly conclude, again, this is not sort of the standard military operation, which was the case in the Ninth Circuit case and the Second Circuit case, Matar and Dogan. Both of those cases involved legitimate military targets. They were going after Hamas victims. They were enforcing a blockade. As Your Honor,
Both of those were Israeli defense folks, right?
correct, Your Honor. And in both of those cases, Israel said to the United States diplomatically, this is official capacity conduct. The United States agreed and issued a suggestion of immunity to those courts. And those courts recognized it. And so it's just not at all what we're faced with here, where no sovereign has taken a position. If there's no further questions, I have nothing further. Thank you, Your Honor. We'd ask that you affirm the district court's decision below.
All right, Mr. Heath.
Your Honors, I believe the last point addressed by my friend on the other side regarding the facts of Matar and Dogan is exactly why the jus cogens exception should not be applicable here. Here, what they've done is they've characterized this as a jus cogens allegation that there was intentional targeting of the journalists, but in a military operation like this, any number of different outcomes could have occurred. It could have been a planned military ambush in which the Dutch journalists were collateral damage, such as the facts of Matar and Dogan, but they
Wasn't there
characterized it
evidence-
otherwise.
Wasn't there evidence that the fact that these journalists were foreign journalists, Dutch journalists, known at the time?
They were known, but it doesn't mean that,
And, known by your client?
Your Honor, that's the allegation,
That's it.
and my client does not, right?
Yeah.
And that- again, this goes to the merits, and that's the very
I understand. but
essence of the issue of
It goes a little
this.
to the nature of the conduct, though, too, isn't it? I mean, if you shoot unarmed prisoners, or you shoot civilians, you go into a village and just shoot civilians because they're live in the country.
But that's not what occurred here, Your Honor.
No, I know, but I'm hypothetically talking about those circumstances would be not part of the military operation impliedly authorized by the sovereign, would they?
Yeah, in that situation where you go in and just kill innocent civilians who live in a village, that would be very different. But here, there were armed guerrillas involved on the outside of the operation, and this is at night in a hotly contested war zone. That's what the other side alleges. Now, when we shift away from the facts and go back to the law, this whole notion of jus cogens really is not a doctrine of U.S. law. It's a principle of international law, but that principle in international law has only been applied in the criminal context and where the jus cogens violations occurs in the foreign state.
So
It's
how
not
do
been
you,
a
how, if that's so, how do you characterize our decisions on that?
Your Honor, the decision there in Yusuf, again,
Are they
there was,
both, take the second one, Warwick.
right, and well, Warfa really,
Warfa,
the council there again conceded and did not try to distinguish Yusuf and the Warfa matter. But in Yusuf, it was a situation in
We
which,
still applied the doctrine, didn't we, in a civilian context?
that's right, Warfa did, but the
And
point.
so was that error?
Your Honor, we're not saying that should be overruled and should be overturned. We're saying we have to look at the facts of the matter here. And as a matter of federal common law, when we apply it here, the allegations of jus cogens violations, it might be relevant to whether immunity should attach, and that was what Yusuf and Warfa said. But we don't believe the court should extend that to this case as a matter of what is federal common law. If we talk about where this whole doctrine of immunity comes from, it's really as a matter of advancing executive foreign policy. And the executive branch throughout the decades have come out and said, we oppose a jus cogens exception. And I think the reason why is very important as this court considers what impact.
Under the Torture Victims Protection Act, it seems to me your argument is that jus cogens simply cannot be applied there.
Your Honor, we're saying that there is no jus cogens exception to an immunity in which there are no waivers of immunity under the TVPA. Congress, right? So when we're talking about jurisdiction here, it's really Congress that sets the jurisdiction of Article 3 courts. And they could have allowed this suit by either, one, stripping foreign states of immunity for jus cogens violations, or two, enacting a waiver of immunity in the TVPA, but they did neither. The Fifth Circuit has found that. The Ninth Circuit has found that as well, the Obiano case and the Dogan case. And I think that's very important because Congress was dealing with claims that essentially dealt with allegations of jus cogens violations. It was at their forefront, yet they chose not to enact any waivers. And that's, again, a key point here because it also leads to what the executive branch has warned against. They want to protect U.S. foreign officials and our troops abroad from facing a similar fate if this exception were to be applied generally. And really for what? Again, this fiction that no sovereign can officially authorize conduct violating jus cogens. Our Supreme Court shattered that legal fiction in Nelson versus Saudi Arabia. They said that a sovereign's exercise of its police powers, however monstrous, remains a sovereign act. And also the Supreme Court has recognized the majority international view is not to apply jus cogens exceptions in civil cases. I see my time is up. Thank you, Your Honor.
Thank you. We'll come down and greet counsel and proceed on to the last case. The next case we'll hear this morning is McMaster versus United States Department of Labor. And Mr. Lambert, whenever you're ready.
Thank you, Your Honor, and may it please the court. In 2016, OSHA published an interim final rule that required state plans to increase their civil penalties to match federal ones for the state plans to maintain their at least as effective as status under federal law. That mandate is incompatible with the text of the OSHA Act, but OSHA went years without enforcing the mandate. When it finally threatened to do so in 2022, South Carolina sued to challenge it. The district court dismissed the case, however, under an either-or theory.
Just a minute, you said in 2022, I thought they always had a clause in there that directed you to bring your rules in compliance with the federal OSHA.
Judge Niemeyer, I think this is where the timeline of exactly what OSHA did is critical because what OSHA did in those FAME reports changed.
Well, they changed, but it didn't mean that there was a lack of interest in enforcing. It seems to me they just chose not to at that point, but what did they say in the report in, say, 2016?
So the rule came out in July 2016. It was
Right.
first noticed in the 2017 FAME report, and it just noted that South Carolina had not completed the legislative process. The critical thing came in
And they
the
included that same notation all the way up to 2022, right?
No, not exactly, Judge Niemeyer, and this is where the facts get really important. In the 2018 FAME report, OSHA said, when it came to the civil penalties, this may be a finding the next year if South Carolina did not take significant steps
Yeah.
to increase the penalties. Fast forward a year when the 2019 FAME
Right.
report comes out, South Carolina had taken no steps.
Right.
OSHA did not make it a finding, and OSHA did not even repeat the threat to make it a
What
finding.
did they say?
OSHA left it simply as a new issue and noted that the state had not completed the legislative changes. That was it. The threat was gone, and that's significant because OSHA's own manual.
Well, you know, the question is, what do you have to say? The opposition of that, the opposing position would be there was some abandonment or dissipation, as you argue.
Yes, sir.
But it looks like there never was that. It looks like they're always asserting it. Their level of interest changed from time to time. They say, you know, we mean it, but they never abandoned the position that South Carolina had to come into compliance, right?
Two thoughts in response to that, Judge Niemeyer. The first is that the threat has to be credible for there to be an Article 3 injury. The threat became uncredible after OSHA threatened to make it a finding and then walked away from that in 2019 and continued to stay away from it in the 2020 FAME report. My second thought is to look around the country at other state plans. South Carolina was not unique in its position to wanting not to increase its civil penalties and not doing so in this time. During these years from 2016 to 2021, you've got Indiana, Kentucky, Maryland, Michigan, Minnesota, North Carolina, Tennessee, and Utah, all in the same position as South Carolina. None of them were taking OSHA's threats, if we can call them threats at this point, seriously enough to think that OSHA actually meant business as to enforcing its findings.
What does that mean? What is that? That's like telling a trooper that I wasn't the only person speeding. You still get a ticket if you're speeding.
But if OSHA,
In other words, you're taking the risk that eventually it may just go away. They were consistent. You're not in compliance. In 2016, they told you that. And you're saying, I get the benefit of taking the gamble and say, maybe they forgot about it. Maybe they forgot about it. Oh, man's credible as far as I'm concerned. You don't get to decide when it's credible. It's credible when the United States government and the agencies tell you you're not in compliance. That is the credibility.
two thoughts, Judge Judge Gregory. The first one is to the trooper example. This wasn't as if the trooper was pulling some people but not others. The trooper was pulling no one here. The speed limit simply wasn't being enforced, and because OSHA wasn't moving against any of the state plans.
Well, you just named about 6. We got 50 in the
Well,
United States.
Your Honor, when it comes to state plans under OSHA, about half the states have a state plan. Half the states are governed.
Why wouldn't this be like the trooper pulling them over and giving them a warning?
Your Honor, the warnings eventually began to mean nothing. So I think I would point to our brief with the library patron example, where you're told time and again, if you return the books late, you'll receive a fine, but no one's ever.
That doesn't mean we're abandoning our position of enforcement or that we will not enforce. What it basically says, we have not decided to enforce, but they never dissipated the notion or advising you every single year that you were not in compliance. And when they finally tried to, they hyped it a couple of times. I said, we'll take the next step and make a finding, and then they backed off that. But they still advised you that you're violating. In other words, you're still getting warnings.
Well, Judge Niemeyer, I think we need to go back to the fundamental question of what is a credible threat injury that gives you standing under Article 3. And you have to have something that's not a speculative threat of enforcement, but it has to be imminent and credible. And OSHA's credibility of the threat went away after OSHA threatened to make it a finding in the 2018 FAME report and then failed to do so the next year and failed to do so the next year. When things changed, when the threat, whatever threat came with the rules publication in 2016 went away after OSHA did not enforce it after that 2018 high water mark.
All right, well, let
It
me
changed.
ask you
Yes.
to clarify here. As I understand your argument on appeal, you say there were 2 injuries. one in 2016, but that dissipated over time, and then another one in 2022. And there's no argument that there was equitable tolling or something like that. It just went away. But in the district court, you said, or somebody, whoever's representing the state, said there was no injury in 2016. And if there was, we ought to apply equitable tolling. And I don't see where this dissipation argument was ever made below.
Your Honor, I want to be very specific as to the argument below and the context in which it was raised. The government's argument in the motion to dismiss, I think this is around page 50, 55 of the joint appendix, was that the injury began in 2016 and the clock had run, and then the government raised, and it has not been told by the first lawsuit that was filed. The argument we raised in response was the injury that gives rise to this case occurred in 2022, and that OSHA's non-enforcement in the years before that meant the state had no injury. The tolling argument that was made below was in response to what the government made. We have not pushed the tolling argument on appeal.
How about page 64 of the joint appendix? Where
Yes,
you
sir.
say there could not point to an Article III injury.
In the years before, and in fairness, Judge Agee, that briefing probably could have been clearer, but we're also arguing in the span of a page there, what we're getting to argue in the span of the better part of 10 pages on appeal to tease out the dissipation. The core question, and as this court said in Boyd, variations on an argument made
The
below.
core question to me, though, seems to be whether or not there was a waiver here, because the argument that you're making now on dissipation, I just, if it was made below, if you could point it out, that'd be wonderful. I'm simply not seeing it.
Your Honor, I don't think we used the word dissipation below, so let me own that, but let me try and show you that we did make the same fundamental argument below that we're making now. And the argument we're pushing now is that the injury that gives rise to this case occurred in 2022, that it is a distinct credible threat injury than the one that arose in 2016 from the rules publication. And the threat that arose in 2022 came from two things OSHA did, and it's confirmed by a third thing. The first thing.
You say on appeal, yeah, there was an injury in 2016. What I'm looking for is, where do you say in the district court, yeah, there was an injury in 2016, but it went away over time, as opposed to we should stop the clock because there's equitable tolling?
Your Honor, we did not say that explicitly below, but I want to make sure I make.
Why do you get to say it now?
Because what we're arguing about now is what we argued about below, and that's that 2022 is the time when the injury that gave rise to this case happened. Certainly, the final agency action in both instances is the rules publication in 2016, but you can have the same agency action and have separate injuries arise from them. Just like you could have the same tax law, pay the tax twice, and be injured on two separate occasions. The first credible threat that arose was from the rules publication. That was a distinct injury from the enforcement that came later. And our fundamental argument below was we have a 2022 injury that gives rise to this claim, and we even said there at page 64 there was non-enforcement in the years before. Whether there was an injury in 2016 at all is ultimately irrelevant to whether we have a distinct new injury in 2022. And that's what I believe we do have from these two things OSHA did. The first was its notice of the revocation of Arizona's state plan, based in part on the fact that Arizona had failed to increase its civil penalties. That was significant because, as far as we can find, it is the first time OSHA has ever threatened to revoke a state plan's final approval. The second thing is what OSHA did to South Carolina as well as other states, which was include a finding in the FAME report published that summer. That was the 2021 FAME report. There was about a 6-month lag time, where it made the civil penalties a finding for the very first time. And if you look around the country, it wasn't just South Carolina who noticed a change in OSHA's enforcement posture. Other states did too. As we point out in our blue brief, both North Carolina and Minnesota moved very quickly to increase their civil penalties after those two actions from OSHA. I think other states did the same. If you were to survey the country, I think Maryland and Utah, for example, increased their penalties in that same little window as well. So what you have is not just South Carolina noticing something has changed with OSHA in 2022, but you have the rest of the state plans across the country as well. Judge Gregory, you had mentioned something earlier about counting states. I think I got pulled away, but I want to make sure I'm clear on something. Half the states have a state plan. Half the states are governed by federal guidelines. Some states willingly and quickly increase their civil penalties when OSHA first said so back, the better part of a decade ago. But there were more than a handful of states that resisted the idea that they should be required to do so. And the states that continued to resist that all noticed this change in 2022. That's the credible threat injury that arises here.
Let me ask you about 2016, when they told you you had to be in compliance. Could you have brought a lawsuit then and challenged that?
Your Honor, I think we could have brought it in 2016. I'll go as far as to say that I think we could have brought it because of a credible threat injury after publication of the
Well,
28.
the credible threat, I'm just reading Corner Post,
Yes, sir.
thinking of Corner Post, and Corner Post keeps focusing on when you could have brought a claim. And they raise it in many different ways, and threat of injury is, of course, one, but being aggrieved is another. When you could have brought a lawsuit is the one that emphasized most. And if you could have brought it, then it seems to me the cause of action accrued on 2016.
And if I could add to that, it still looks like to me on page 64 that below the state said we could not bring a claim in 2016.
So I want to try and take these together, but also keep them distinct.
Well, why don't you
Judges.
take Judge Agee's first, because you just told me that you could have sued in 2016.
Okay. Your Honor, I think the argument at page 64 is focused on pressing to the district court the injury we have here arises from an injury a credible threat that arose in 2022. That looking back at what happened in 2016 was ultimately irrelevant because at least for some period of time, the threat was not there. Whether we talk about a dissipation.
I don't understand that.
All right, so Judge Niemeyer, I think this gets back to your question.
At least the same, in other words, you were told you were out of compliance, and if you disagreed with that, you could have sued. You agreed with that now. 2016, you could have sued. Now, the question is why, if you could have sued then, it seems to me the statute of limitations begins on a Corner Post, right then.
Judge Niemeyer,
And the question is, why does it toll thereafter? What is your argument why that period is not the controlling period?
Your Honor, I don't think it's a question of the statute of limitations and tolling. I think it's a question of injury in fact. If the
No,
credible.
it's when you could have first brought suit. Injury is one way of saying it. Being aggrieved is another way of saying it. In other words, you were told something you disagree with, and you could have sued to correct that. You just agreed with that. You could have sued in 2016. If you could have sued then, the statute of limitations begins. Now, the question is, what stopped it?
What stopped it was when the Article III injury went away.
Wait, tell me when it went away.
My frontline position is it went away when the 2019 FAME report was published and OSHA failed to follow.
What did it say in 2019?
The 2019 FAME report failed to include the
No,
threat
what
of.
did it include?
It included simply that the state had not completed the legislative change. It
And
did.
that's exactly what it said in 2016, right?
2017, yes, Your Honor.
Right.
That was the first year it came in a FAME
There's
report.
no difference from 17 to 19, or whenever it was.
Well, there is a big difference, Judge Niemeyer, and it's the 2018 FAME report. OSHA threatened to make it a finding if you didn't take significant steps. No steps were taken and no finding was made. The threat began to.
They just heightened the pressure, and then but it didn't dissipate the fact that you could have sued. You could have sued in 16, you could have sued in 19, you could have sued in 22. You could have sued any one of those times because the state disagreed.
The state disagreed, but the state doesn't have an Article III injury if there's not a credible threat that OSHA is going to enforce the penalty.
It does, that's my whole point. If you read Corner Post, it's much broader than your notion that there has to be a threat forward.
Well, Your Honor.
What you have to have is you have to be aggrieved by the action. You have to be able to file a lawsuit. Unless Congress has told us otherwise in the legislation at issue, a cause of action does not become complete and present for limitation purpose until the plaintiff can file suit and obtain relief. And could you have filed suit and obtained relief in 2016?
In 16, yes, Your Honor, while there was a credible threat. The relief we would have been seeking
Why is it
was.
a credible threat? They didn't threaten you with anything.
Well, generally, this court has said consistently that a rules publication carries with it a credible threat. After all, why else would the government be publishing the rule?
Well,
But if the government.
Not to belabor this, but the state said at page 64, without defendants taking what is typically the first step in revoking the state plans, plaintiffs could not point to an Article III injury to the state plan to invoke this court's jurisdiction.
Yes,
To
Judge
me, that
Agee.
seems directly contrary to what you're arguing on appeal.
I don't think so, and let me try and reconcile them for you. The briefing in the district court, you're citing, it's page 64, was written in the context of when the lawsuits came in 2022 and in the years right before that. It wasn't trying to reach all the way back to a theory of dissipation, now why it went away. We were trying to drive home the point that there was a new injury that arose in 2022 that was different than what had happened right before that, because before that, there weren't the steps coming from the federal government to enforce the mandate on the state plans. And I would press the court to look across.
The nature of the injury was the same the whole time. The injury was you didn't want to spend the money or increase the amount, and you were resisting doing that. And you were resisting back in 16, you were resisting all the way through, and the government never backed off its position that you had to comply.
The government.
Now, the fact they said on a couple of years, say, we mean what we say, doesn't mean the other years when they said it, they didn't mean it.
Your Honor, if I may briefly
please, of
respond.
course.
Thank you. The government backed away from the seriousness of the threat. The threat is what gives rise to the injury, because the state would have
So your
been.
argument is that when they backed away from the seriousness of the threat, the statute of limitations abated?
Yeah, well, the injury went away, so we couldn't have sought prospective release to enjoin anything at that
Except
point.
it didn't go away because you agreed with me that the statement they made in the following year was the same as they made in 16.
But there was the intervening event of the 2018 FAME report where OSHA made such a greater threat of enforcement.
I think
Thank
I
you, Your Honor.
understand, yeah, okay. All right, Mr. Day? Do you disagree with him?
Regarding what, Your Honor?
Everything.
Everything. At least some things, not everything. Good morning, Your Honors. May it please the court, Kane Day for the federal government. And I think that kind of gets at the point here. What is undisputed is that the only final agency action challenge here was the 2016 IFR. The state of South Carolina's entities that run their state plan have been out of compliance with federal law since then. There have been consistent and repeated FAME reports reminding them of that fact. And I think that is enough alone to resolve this case. Thought through another lens,
What's the explanation? I'm not sure it makes any difference, but what's the explanation? I would have to think about that, but what's the explanation for making a finding during one of the years saying, we're going to go ahead now, and then the next year not doing anything?
Yeah,
Or just going back and reminding them?
I don't know that there's an explanation in the record, and I can't speak to any pre-decisional deliberative explanation that would have occurred behind the record, but I think one can posit many explanations, enforcement resources, decisions about how to implement the plan, a decision to continue working with the state rather than launching full-on enforcement proceedings. I think there are many reasons that would explain that, but I think the fundamental point is that it doesn't amount to a dissipation that completely dissolves the injury. And I'm happy to talk about the other issues in the brief, but unless the court asks questions, we'd ask a different. Thank you.
All right, Mr. Lambert?
Thank you, Your Honor. A couple of thoughts to try and push the court a little more in our direction than it seems to be leaning. The first one as to the waiver question, because I know we need to get over that one out of the gate, Judge Agee, is that the arguments that are being pressed there really have to be read in conjunction with the motion to dismiss that was brought and to which it's responding. I don't think the state there had to take an affirmative position one way or another as to what happened with any threat that arose in 2016. And the way that argument was framed was largely in response to the arguments that OSHA made below. The fundamental question, and I think we would point back to board for this language, you can make variations on the argument below if you're asking the same fundamental question. The fundamental question is, did the state suffer an injury in 2022 that gave rise to an injury in fact? Was there a credible threat?
Let me ask you, you keep focusing on injury, and that's important, of course, but in 2016, when they advised you that you had to come into compliance, what was the injury then?
So the injury then would have been the credible threat of enforcement that came with the rules
Well,
publication.
No, enforcement, that's not injury, the threat of enforcement. The injury was that you were out of compliance and you would have to comply, right?
Your Honor, I don't know that the rule in a vacuum is enough, because you have to sue a federal official to seek declaratory or injunctive relief. The relief we sought was prospective injunctive relief to prevent the mandate from being imposed against the state plan. To seek that relief, you have to have some threat that it's going to be enforced against you. The rule's publication can come with that threat. OSHA may have carried that threat up to the 2018 FAME report, but when OSHA failed to follow through, the reasonable conclusion to draw was that OSHA wasn't looking to enforce it against someone, and it wasn't just South Carolina that thought so. All the other state plans did. What changed was in 2022, OSHA's enforcement priorities. The threat became credible. It was imminent. It had moved against Arizona. It made a finding against South Carolina and the other states. Not only South Carolina,
Let me
but
ask you, did the amount of non-compliance increase over every year when the feds increased their amount?
certainly the delta changed, Your Honor.
Yeah.
But Judge Niemeyer, the district court noted that in the first lawsuit that those annual adjustments were not final agency action. So I don't think you can then say, well, if every year the number's growing, the threat gets bigger. The threat actually has to be the enforcement, whether it's $1 or $1 million. It's the threat that OSHA is going to move against the state plan that creates the injury that gives rise to us bringing this case. We brought it when we got injured from the 2022 threats. That case is timely, and all we're asking for is the opportunity to go back and argue in the district court without a threat to the final plan and betting the farm that OSHA's mandate is inconsistent with the OSH Act. So we would ask that you reverse and remand for more proceedings. Thank you, Your Honor.
All right, we'll adjourn court for the day and come down and greet counsel.
The Honorable Court stands adjourned until tomorrow morning. God save the United States and this honorable court.